This is TV18 and you're watching CNBC TV18.
In a big win for Cyrus Mistry in his legal battle against the Tata Group, the Company Law Appellate Tribunal has restored him as the executive chairman of the group. The tribunal has also held that the appointment of N. Chandrasekharan as executive chairman is illegal as a consequence of what it said. However, the tribunal has allowed the Tata Group 4 weeks to challenge the reinstatement order in the Supreme Court. Remember, Cyrus Mistry was removed as the Tata Sons chairman in October of 2016. Mistry had then moved the NCLT, which was the start of a protracted legal battle. In its order, the NCLAT has made some scathing observations about the Tata Group. It is said, and I quote, "The company's affairs have been or are being conducted in a manner prejudicial and oppressive to members, including appellants Mr. Cyrus Palonji Mistry, as also prejudicial to the interests of the company and its group companies." It also goes on to say Tata companies and winding up of the company would unfairly prejudice the members, but otherwise the facts as narrated above would justify a winding up order on the group, that it was just and equitable and that the company should be wound up, end of quote. Tata Sons has responded to the order and has said, and I quote, "It is not clear as to how the NCLAT order seeks to overrule the decisions taken by shareholders of Tata Sons and listed Tata operating companies at validly constituted shareholder meetings. The NCLAT order appears to even go beyond the specific relief sought by the appellant. We are examining legal options," end of quote. The group added that it will take, of course, appropriate legal recourse. On the other hand, Cyrus Mistry has welcomed the order. He has called it, and I quote, "a victory for the very principles of good governance and minority shareholder rights." He added that it is now time for all stakeholders to work together for sustainable growth and development of the Tata Group. Well, those are the reactions coming in, but let's go across to my colleague Ashmit Kumar, who was the first to break this story and pieces together the judgment that's come in from the NCLAT. Ashmit, it is a complete departure from the NCLT order, which had gone unequivocally in favour of Tata Sons. What is the rationale, the grounds whereby the NCLAT has overturned the NCLT order?
Well, I'll answer that in two parts. First, the rationale and the reasoning, and then the direction. As far as the rationale is concerned, the NCLAT has held that there was power in the hands of the members of Tata Trusts to intervene and to interfere in the functioning of Tata Sons. It also holds that there was, in fact, active interference. It names Ratan Tata as one of the trustees who, in fact, had interfered as far as functioning of Tata Trust is concerned. It also records that there is damage caused in the form of losses that have been incurred by Tata Sons companies. So that is a very important takeaway. This order also says that as far as the removal of Cyrus Mistry is concerned, it was hasty and it was sudden, and that it was done without proper consultation, without proper discussion within the board meeting, and that is indicative of perhaps the efforts and the stress that the board meeting was under from the Tata Trust members. And finally, it says that as far as this removal itself is concerned, there appears to have been a global impact on Tata Group companies. So again, on the basis of all these findings, then come the directions, and there are 5 key directions. Number one, the reinstatement of Cyrus Mistry as the executive chairperson. It wasn't what they were seeking, and this part has also been stayed by the NCLAT for a period of 4 weeks to allow Tata Sons to challenge. The other takeaways are, of course, that the appointment of N. Chandrasekharan has been held to be illegal. So that's another important takeaway. The third key takeaway in terms of directions is that Ratan Tata broadly has been told, do not interfere with the functioning of Tata Sons. And the fourth and the fifth takeaway are with respect to securing the rights of Shapoorji Pallonji Group, whereby NCLAT has held that Article 75 will not be used to force or to compel the Shapoorji Pallonji Group to be forced into selling their stake to Tata Sons. So broadly, a very strongly worded order. In fact, at one point, the NCLAT also says that they were close to ordering winding up of the company, if not for the larger interests of the members at stake. So a strongly worded order. Tata Sons, of course, will now take recourse to legal remedies and will move the apex court.
Right. Thanks very much, Ashmit, for joining us with what transpired in court and the finer print of the judgment that's come in from the NCLAT. Now, we've spoken with Cyrus Mistry's counsels, Arya Masundaram and Somashekhar Sundaresan. Arya Masundaram said that this was not a personal battle being carried out by Cyrus Mistry. It was a battle in the larger interest of the Tata Group. Somashekhar Sundaresan added that Cyrus Mistry was not making the case to walk back to office. Take a look.
The manner in which he was removed as executive chairman was against all procedures. Don't forget that these were the minority shareholder companies who had moved the NCLT. And the minority shareholder companies made it clear that it was not a question of Mr. Mistry's personal interests in chairmanship or otherwise which was of relevance, but the minority shareholders' interests and the interest in a good corporate governance, which would all be necessary for the good management of the company. This was not a personal battle being carried out, but really a battle in larger interests.
From this order that's been addressed, it is very important to remain a public company which has a higher standard of governance, whereas a private limited company has a much diluted standard of governance. And on Article 75(2), the ruling essentially is that it's an exceptional power to be used in exceptional circumstances. In fact, the position taken by both sides quite clearly was that it had not been put to use, but the risk of it being put to use, considering events that had transpired in the last 3 years, was what was in play, and the declaration that it's an exceptional power to be used in exceptional circumstances is welcome from our end.
Well, the counsel's there for Cyrus Mistry. Joining me now to take the discussion forward on what we can expect are Prabal Basu, Roy, Management Advisor, and Suhas Tuljaphurkar, Managing Partner at Legacy. Gentlemen, appreciate you joining us here on the program. Suhas, let me start by asking you, what a turn of events it's turned out to be. The NCLT, as I pointed out, unequivocally ruling in favor of the Tatas, and now you have the NCLAT on every parameter that the NCLT had ruled in favor of the Tatas, saying exactly the opposite. It is clear that the Tatas will approach the Supreme Court. It's a question of when and not if. How do you read these developments and where this leaves this bitter boardroom battle?
You see, if you recollect, in 2016 we had predicted, Shereen, and we had said that the last word will come from the Supreme Court on this matter, because neither of the party is going to kind of accept any judgments that will be given by the lower courts. So obviously it's heading towards the Supreme Court. Having said that, if you look at the NCLAT order, the 175-page order, I think the manner in which the issues have been dealt with in this order will require consideration. Firstly, from the point of view of shareholders' democracy and shareholders' democracy and democratic principles governing the corporates today. The second consideration, which is to the foremost, would be probably the corporate governance related issues. If you were to put it broadly in terms of 3 or 4 buckets, one would be the performance evaluation of the board of directors. I think that's come to the foreground once again, and I think the judgment all across heavily relies on the fact that the performance or the evaluation of the performance was something different, and actually the action does not commensurate with what was there in the evaluation reports. The other aspects, such as just an equitable ground for winding up, are technical in nature, but the question which is broadly requires to be considered and to be addressed is whether the removal of a director is a directorial action followed up by shareholders' approval, and if that is the case in terms of shareholders' democracy, where does this judgment stand?
Yeah.
These are some of the considerations that will come to the foreground as we move forward.
That certainly will be the premise of the argument that the Tatas hope to push forward. If you go by the statement that's been issued by the Tatas, and let me get Prabal to respond to that, the Tata Sons saying it is not clear as to how the NCLAT order seeks to overrule the decisions taken by shareholders of Tata Sons and listed Tata operating companies at validly constituted shareholder meetings. This clearly is going to be part of the plea as and when they choose to move the Supreme Court. Prabal, in light of what you've seen from the Tatas in this statement and what Suhas was just pointing out, where does this then leave shareholder democracy and the way forward?
Well, the way forward, Shereen, will obviously be determined by the Supreme Court, and they will obviously, Tatas will obviously take it up there and all of that. The substantive point, though, I think, is that between the NCLT judgment, which seemed to be clouded by, Mr. Tata's charisma, if I can say it, because they brought in a thing called a guiding light principle, which is the first time in corporate lexicon something like that came. This judgment has essentially gone to the root of how boards are being effectively run, by a set of very distinguished but compliant board members. And I think that is what is being hit at the core this time. And they have proven through mails and various other actions that board members who were on the board were taking directions from a super director, so to speak. I think that is the very substantive point which will have to be determined, because this will impact corporate boards across the country. And most of us know how boards are effectively run, by a person who controls it. I think that is one of the main things which will happen. And ultimately, I guess, I'm not trying to predict it, but Cyrus Mistry will not like to come back. I do not even know if he'll like to come back and take charge, but it's clearing his name and so and so forth, and that sort of thing will happen.
Yeah. Well, that's the sense that we've got from both his counsels who we've spoken to, Aryaman Sundaram and Somashekar Sundaresan, saying very clearly that this was never about a position, this was never about an office, this was about upholding corporate governance principles, and we stand vindicated today. That's the message coming in there from Cyrus Mistry. But to the point that Prabal was making, Suhasan, let me get you to comment on that. I want to quote to you what the judgment says. There was complete confusion in the board about the governance framework of the company Tata Sons Limited, as before deciding any matter or by taking any resolution by the board, decision used to be taken by Mr. Ratan Tata for Tata Trust, in which Mr. Nitin Noria and Mr. N.A. Soonawala were taking active part. Now, this has been at the nub and the heart of one of the arguments presented by the Cyrus Mistry camp in the legal battle, outside of that boardroom battle as well, and that now seems to have been upheld very clearly by the NCLAT.
You see, Shereen, if I were to read this portion of the judgment, I think this is a ruling on the merits of the matter. It's merely stating what probably the appellant contended and holding it to be true. There is something in between between these two parameters, where on the merits, I think NCLT is the most appropriate forum to determine whether actually the decision making was like so.
Okay.
Not NCLAT. NCLAT will look at the matters and issues of law, ought to be looking at matters and issues of law. And therefore, from that perspective, I don't think this to be a conclusive and evidentiary factual ruling from that perspective. Having said that, I think one of the very critical elements of the operative portion of the order is that the reinstatement is actually for the rest of the tenure of Mr. Cyrus Mistry. Nowhere in the order we come to know what was the tenure, because reinstatement can happen only if the tenure is alive today, if the contractual arrangement continues. If his contractual arrangement as the executive chairman ended somewhere prior to this ruling, then how would the reinstatement be effected? Nowhere in the order we come to the conclusion that what was the tenure. All the date of appointment has been mentioned, and the tenure insofar as when he was executive deputy chairman, that's been mentioned. So giving effect to my reading is that there will have to be some workable solution will probably emerge in the interim as and when the appeal will get decided by the Supreme Court.
By the Supreme Court. Let me also bring in Mohit Saraf of Luthra & Luthra. Mohit, many thanks for joining us here. We are, of course, discussing the implications of the order that's come in from the NCLAT, while one part of the order has been stayed, which is the reinstatement of Cyrus Mistry for a period of 4 weeks, which will give the Tatas time to move the Supreme Court, I would imagine. On every other parameter, on every other ground that the NCLT had ruled in favor of the Tatas, the NCLAT has ruled against the Tatas in favor of Cyrus Mistry. For instance, from the transition of the company from public to private, that has now been struck down by the NCLAT. On alleged interference by Mr. Ratan Tata and Mr. Soonawala, which was not upheld by the NCLT in favor of Cyrus Mistry, has now been upheld in favor of Cyrus Mistry by the NCLAT. And several other parameters where the NCLT had ruled in favor of the Tatas, now the NCLAT has overturned. What are the implications, Mohit, of this for the group?
Actually, Shereen, when I read the order, a part of the order, actually I could just read. I'm actually aghast because the order is not based on law. It is based on how much investment you have made, your relationship between the family, how nothing was put in the law, nothing was put in the contract, nothing was put in the articles, but it is still binding on people because I think the judge has taken much more higher moral ground, which is outside, in my understanding of common law. If it is not reflected in the article, if it is not reflected in the Companies Act, how can that govern the relationship between the partner? I'm aghast. I don't understand that. So really, I feel that the judge has actually taken it to a different level. So this order will definitely get stayed by Supreme Court because it lacks legal basis. But in the interim, for the next 4 weeks, it will create confusion because it'll actually, but technically, actually the Tatas can actually call a board meeting and remove him tomorrow. Because it cannot take the existing director's right to remove him even after reinstatement. And also it cannot nullify all the decisions which the board has taken for last 2 years just because his removal. But I think one important thing which I still fail to understand, articles under the law, the shareholders have a right to remove directors. And that right is with the shareholder.
Yes.
Now the majority of Tata Sons removed him. So that right you cannot take away. And the other thing which is important is that all these companies are listed companies where Tata Sons have appointed him. It is the listed board which has removed Cyrus Mistry. Now, I don't know on what law can you reinstate him in all these boards. And this is, I think it actually, in my view, I can't find a law. It is based on high moral ground that how decisions were being taken. I think I can understand that they said there is a section of 121A he talks about in the article which was used for interference. I can understand that he can say the court can say hold that this section was maybe is in contravention to the law and the Companies Act and can be null and void. But I don't know what but again I don't agree with him. But I can still say that, okay, at least a case has to be based on either law or the articles, which is the governing document for the company. But it cannot be based on something which is superficial. In my view, this whole judgment is a very superficial. It is same, Shereen, if you remember, this is a similar judgment at which NCLAT had given for SR Steel, where the law has said the committee of creditors are the final. And they said, and the court had said that committee of creditors cannot, and they should not have a final decision, and the court can interfere. The same thing, I think, in my view,
and that,
based not based on any law. Actually, I was going to actually, I just could read few pages of maybe 50, 60 pages of that decision, and I was actually could not find anything which is based on law. It's all based on family relationship, investment of 1 lakh crore.
You're using strong words. You're saying you're aghast with the judgment, that this is a judgment that's not based on law but on high moral ground. But Mohit, and I think this is going to be something that will interest investors, it will interest shareholders, and I want to get all three of you to comment on that, but specifically Suhas and you to comment on that because that's a point of law. You said that nothing that has transpired over the last 2 years, decisions under the stewardship of N. Chandrasekharan as the executive chairman, etc., can be overturned. That process is now done and dusted. There cannot be a review of that. Just for the benefit of investors, shareholders, wanted clarity on that. Mohit.
Yes, absolutely. My understanding about law is that those decisions are binding because decisions at the board level can only be taken by majority of the board, and the majority voted for it. That cannot be taken away just because one member has been reinstated. And again, one important thing is even Cyrus Mistry petition, what he asked for, that he's a minority, and he said he should be restored as a board member. He never asked, even in my understanding, that he should be restored as the chairman of the board. So actually, NCLAT has gone way beyond the petition.
That is the point of view of the Tatas as well, that the NCLAT has provided relief where relief wasn't even sought by Cyrus Mistry. But Suhas, just to sort of take things forward now in terms of what this is actually going to mean, there was a concern on whether this means that there will be a managerial black hole over the next few weeks, a vacuum, so to speak. Give us a sense of what transpires now till the Supreme Court decides to intervene.
You see, I don't think life will change drastically from an investor's perspective as well. I'm sure if the logic with which this judgment has come out is to say that removal of Mr. Cyrus Mistry actually led to uncertainty, and therefore it was not in the interest of Tata Sons, of the companies, operating companies, as also public at large. The uncertainty that this judgment has created is probably larger in its scope and magnitude than actually removal of Mr. Cyrus Mistry. So from that perspective, very quickly before the Supreme Court, I'm sure there will be some workable arrangement worked out between the parties so that the operating companies don't get affected. Also, please, we have to understand that the operating companies, which are large and listed entities, have various shareholders, including the institutional shareholders, small shareholders, and therefore I think confidence needs to be restored by a working arrangement. I'm not going to kind of comment upon the past decisions because I don't think these were bona fide decisions taken in the course of businesses, and actually not that this was done in a surreptitious manner. It was actually the appointment of Mr. Chandra was done with knowledge to everybody. All stakeholders were aware about it. NCLT was aware about it. NCLAT was aware about it. So from that perspective, I doubt whether any of the past decisions will be impugned or will be questioned. Way going forward, a very quick working arrangement needs to be put together, and I'm sure it would be put together. Which will give confidence to everybody. You see, coming back to your first argument in terms of winding up, I think the manner in which the just and equitable ground relating to winding up has been made out is that it says that the manner in which this was Mr. Mistry was removed was prejudicial and oppressive, and therefore it leads to a conclusion that there is possibly a case for just and winding up order. I don't think this can be summarily concluded, because I don't think in any of the operating companies or Tata Group as a whole, it's just and equitable to wind up the businesses. So I'm sure investors will see through
Well, he does say that, yes, and we will have to see what finally transpires in this matter. As Suhas has been pointing out over the last 2 years that we've been discussing this boardroom battle, that the final word will be with the Supreme Court. But Prabal, I want to come back to you now. You've heard, of course, the legal points of view and the legal arguments, and we will see how this plays out in the apex court. But, as someone who is who has been watching this story now, once again, it opens the door to uncertainty at one of India's largest conglomerates.
Shereen, I have a slightly divergent view on this because, please appreciate that the crux of the issue for which Cyrus Mistry was perhaps removed was the fact that he questioned repeated strategy failures of Ratan Tata in Chorus, in various matters, Tata Motors, etc. And he was trying to set things right in a governance mechanism which he thought was right, and which perhaps but the way in which it was being done did not quite agree with Mr. Tata's views at that point in time. This was the basic cause of the conflict. Now, when Chandra came in, and I've written about this extensively over the last couple of years, when Chandra came in, the steps he is taking to undo exactly those excesses are pretty much similar. They're very, very similar. It's just that this time around, he is managing the environment very well, right? So I don't believe any of the actions will get changed or anything of that matter. And Cyrus Mistry is also not asked for that. So that I don't think will happen. And so therefore the uncertainty part, to some extent, the stock markets will get affected, but it will be only for a short period of time, according to me. And yes, there can be a decision vacuum for the next 3 to 4 weeks. That could happen. So new major steps may not be taken. But all these are operating entities, like all the operating listed entities will carry on as they are. So that is how it will probably play out. I mean, I don't think this will create too much of a management vacuum, so to speak, apart from some decision making, new decision making, which can take place at this time.
Sure. Sure. Mohit, what is now going to be crucial is, which bench hears this matter in the Supreme Court. Of course, the Supreme Court headed into vacation, corporate law being taken up by the Chief Justice as well as Arun Mishra. Do you expect the Tatas to move even the vacation bench?
Possibly, absolutely. I think this is such a difficult judgment that they will try to move quicker. But also remember one thing. I think there is maybe I'm just throwing a thing, because I think today, whatever said and done, whether right or wrong, Cyrus in a way is in a better position. Now he can actually tomorrow morning just resign and be done with it. So he's actually, because he knows that this position cannot be upheld at the Supreme Court level. So he can, for all you know, that before Tata moves in, he will just resign and just say that my position has been vindicated and I just want a board position, and which probably he can get and just be stay. Because remember one important thing, which is very important, Shereen, to understand, that all the listed companies where Cyrus Mistry was removed, it was removed by the board of those companies. So it was not removed by Tata Sons. And therefore, again, the argument gets very weak. Yeah.
Yes, you're bolstering the point that the Tatas are making in their argument in response to the NCLAT judgment. But it's an interesting take that's come in there from Mohit Saraf. So, Has, I'll get you to close the show with your comments on what you make of what Mohit just said. And I go back to Cyrus Mistry's statement. The last lines, I believe it is now time that all of us work together for sustainable growth and development of the Tata Group, an institution that we all cherish. So, Has, do you believe that Mohit might have something there?
You see, Shereen, my view is that, whether it is ugly, bad or good, this order is there currently on record. We'll have to kind of look at it. If you were to look at what are the positives coming out of it, is that the discussion about the corporate governance in Indian scenario today is coming to the forefront. Do you actually continue to take decisions outside the board, or do you take decisions in the board and demonstrate it correctly? It's not about whether the decisions happen in the board or outside. It's the demonstration of the fact that you're following corporate governance norm, whether it's decision at the board level or whether it's evaluation of the performance of the directors. The good thing about it is that these kind of corporate governance related issues are coming to the forefront for consideration. And I think from that perspective, I think the credit must be given that the corporate governance related issues will be kind of coming to the forefront and will be looked at it in a positive manner.
Absolutely, and that scrutiny on corporate governance standards is good for shareholder democracy. It's good for shareholders and investors, and we do hope that there will be much more scrutiny of corporate governance standards across India Inc. As you pointed out, the conversation has of course been underway for the last few years, and this bitter boardroom battle was only one of the catalysts of speeding up that conversation, but hopefully meaningful action will also back it up. Prabal Basu, Suhas Tulchapulkar, Mohit Saraf, appreciate you joining us here on CNBC TV 18 with your take on the Tata Mistry battle and what this NCLAT judgment now means. We'll take a break. There's a lot more coming up. Don't go anywhere.